Thank you for coming out. Short notice. I have a statement to read, and then I'll be happy to take some questions if my PR consultant is around. Hey, Ron. All right. On October the 24th of 2014, various police units in Northampton County engaged in a vehicle pursuit that resulted in the use of deadly force by an Easton police officer and the death of Richard Scheuermann III within the city of Easton. On the day that these events unfolded, I immediately asked the Pennsylvania State Police to assume the investigation in order to assure an independent and unbiased investigation. The Pennsylvania State Police conducted a full and complete investigation, which included, but was not limited to, a review of all available video recordings, audio recordings, statements of witnesses, statements of police officers, and consultation with the Office of Coroner. On Monday, December the 8th, 2014, I met, as you know, with investigators from the Pennsylvania State Police, as well as the Northampton County Coroner's Office. Also present at that time was Dr. Zhang Hua, the forensic pathologist who conducted the autopsy on Mr. Scheuermann, as well as the coroner, Zachary Lysick. The meeting lasted 2.5 hours, and at that time included an oral report from investigators, an oral report from Dr. Hua, as well as a PowerPoint presentation that included all audio and video of the police pursuit, crash, and subsequent events, including the use of deadly force by one Easton police officer. Still photographs were also reviewed. Upon the conclusion of that briefing, I requested that police obtain 2 additional pieces of information. I now have those additional pieces of information. In addition, I also requested at that time that the coroner officially certify the cause and manner of death. That has also now occurred. The coroner has ruled the matter to be a homicide and that the cause of death was primarily a fatal gunshot wound, but also has noted contributing causes. Also on that date of December 8th, I contacted Attorney Josh Carrolley, counsel for the Scheuermann family. It was my understanding at that time that he had conducted his own investigation, and I wanted to give him an opportunity, if he so choose, to share any information that he may have developed with me, so that all relevant information that is out there can be considered in determining whether or not the use of deadly force by police was justified. Although I was confident at that time, and still am, that the Pennsylvania State Police had provided all relevant information, I welcomed any additional information that Mr. Carrolley may have uncovered or developed that for whatever reasons may not have been given to Pennsylvania State Police investigators. I also noted on December 8th that the events as they unfolded on October 24, 2014, and as I observed on the video, involved seconds and minutes. In fairness to the police officer involved and to the victim's family, I cautioned that there should not be a rush to judgment and that it was necessary to take whatever time required to make the right decision with respect to the use of deadly force. I also indicated at that time that I did not rule out the use of the Northampton County Grand Jury or a referral to the Pennsylvania Office of Attorney General as a potential best course to assure that the ultimate decision rendered on the use of deadly force is objective, unbiased, and transparent. Last week, on Thursday, December 18th, the coroner delivered the final autopsy report to my office, so I did have that in writing. And on Friday, December 19th, the Pennsylvania State Police delivered to my office 2 large binders containing their final report and the statements of all witnesses. Since that time, over the weekend, I've had the opportunity to consider this matter in more detail. I note that in previous matters involving the use of deadly force by police officers in Northampton County that resulted in the deaths of individuals, I did refer those matters to the Office of Attorney General. A few cases are noteworthy. On April 23rd of 1997, Bethlehem police conducted a raid at a residence in the city of Bethlehem occupied by John D. Herco and his girlfriend. Mr. Herco was killed by bullets fired from weapons of Bethlehem police officers. I referred that matter to the Pennsylvania Office of Attorney General. In September of 1997, the Attorney General at that time, Michael Fisher, ruled that the actions of the Bethlehem police were justifiable and that the use of deadly force was justified and no charges would be filed against any Bethlehem police officers. On December 24th of 1998, John E. Rapp was shot once in the back of the head by an Easton police officer, Scott Cameron, as he drove away from a roadside parking space in Hackett's Park. Officer Cameron had first encountered Mr. Rapp slumped over the wheel of a pickup truck. Officer Cameron told investigators that he feared for his life after Rapp awoke and put the pickup truck in gear and knocked him over. Officer Cameron told investigators that the pickup truck slightly struck him and that he fired once through the back of the window as Rapp pulled away. I referred that matter also to the Pennsylvania Attorney General for investigation and for a charging decision. The Office of Attorney General in that case filed criminal charges against Officer Cameron, and in November of 1999, Officer Cameron entered a guilty plea to the charge of involuntary manslaughter. On Good Friday in March of 2005, Easton Police Officer Jesse Solomon was shot inside Easton Police Headquarters by fellow officer Matthew Renninger. I referred this matter to the Pennsylvania Office of Attorney General. A state grand jury was utilized. Then Attorney General Tom Corbett later ruled that the shooting was accidental and no criminal charges were filed. Each of the aforesaid cases involved a decision as to the use of deadly force by a police officer in Northampton County. In each of those cases, I deferred to the Office of Attorney General. Those decisions were made by me at that time were based upon my view that all the cases created either an actual or an appearance of a conflict of interest. As noted, one case resulted in criminal charges filed against a police officer. One case resulted in a decision that the use of deadly force was justifiable, homicide, and one case was ruled an accident. In all of those cases, the Office of Attorney General made the charging decision. In those cases, the Office of Attorney General had absolutely no prior relationships with either the police officers involved, the victims, or family members of the victims. After considering my decisions in those cases and looking at the matter involving Mr. Scheuermann, I have come to the conclusion that the best course to assure a completely objective and unbiased decision-making process is to also refer this matter to the independently elected Pennsylvania Attorney General. The Office of District Attorney has a long-standing relationships with local police officers in Easton, including the officer involved in this matter. I have also recently learned that I have some personal acquaintances that are related to some members of the victim's family. I believe that these competing interests raises potential conflicts of interest issues that requires me to act with the utmost caution in assuring that whatever decision is made is based solely upon the facts and the law, and not at all influenced by any personal feelings I may have about the police officer involved in this matter and or acquaintances with some members of the victim's family. Based upon the history of the handling of these types of matters by my office and the present climate involving police shootings, I am referring this matter to the Pennsylvania Office of Attorney General, who will review the findings of Pennsylvania State Police investigators and all relevant information for a decision as to whether or not the officer in the City of Easton Police Department involved in this matter did or did not act justifiably in the use of deadly force. It will be up to the Office of Attorney General to decide whether this decision can be made without the use of a statewide grand jury. In that regard, I did have a conversation with Lawrence Cherba, Executive Deputy Attorney General in the Criminal Law Division of the Office of Attorney General, who has indicated to me that based upon the information I have supplied, that they will in fact take this case for review and a charging decision. It is my hope that the citizens of Northampton County know that the actions taken today are done because of my sincere belief that whatever decision is made, it must be made with an independent set of eyes and not at all influenced by past or present relationships with police officers who serve in this community or relationships with any other citizens. I do have a copy of my statement here for your use, and I'll be happy to take some questions.
John,
yes, Tom.
Why is it that you're reaching this decision now? Not to criticize, but a lot of these facts that you worked with Eastern PD, that your history of going with the AG, why did you only reach a decision now as opposed to?
Well, it's an ongoing process, Tom. You know, this is something that I've been thinking about, and as you know, from day one when we first got the information, again, I got an oral report on December 8th. I indicated that I wasn't sure how I wanted to handle this, and the investigation is ongoing in that respect from that time forward, and it really wasn't complete until Friday when I got all the reports in, because neither myself nor the AG's office is going to just rely on an oral presentation of information in order to make a decision. So there's no issue here as to delaying this decision, because the decision couldn't be made until the reports were final, which is Friday. Today's Monday. It's just the way things work here. So I did have the luxury of some time to look at this whole picture, looking at the facts of the case as they developed, and just recently learning also that in addition to knowing the officer, and that's one criteria that we look at, I also know some acquaintances of family members of this victim. I did not recognize the name Scheuermann, and I don't think I knew him at all, but I do know some people that are related to him. Some people have an interest in him. And looking at this entire picture, I felt that I needed to give it time to figure out what was the best way to do this. I also considered use of the grand jury. But because that the investigation wasn't over until we get all of the facts in, including the reports in my hand, which was Friday, I felt that I would have the time to make that decision rather than just immediately sending out to the Attorney General's office. So it was a decision that, and I, quite frankly, as I sat down, I forgot a lot about these past cases. You know, time goes on. 97 and 99 was a while ago, but I thought I went back a little bit in my history because I couldn't remember how we handled some of these cases, whether they were actually in fact for the AG or whether we had made some of these charging decisions. And so when I started to look back, and I found that I was pretty consistent in sending all these cases up to the AG, the top three that I can recall anyway, where a deadly force was used involving and a death occurred. I felt that in order to be consistent with past performance here in this office and policies, that it was better to send this up so that whatever decision is arrived at, no one's going to say, oh, well, Morganelli likes the cop or worked with this officer in the past, which I have, or he likes the family members, so therefore he, so it was just a decision that I thought was better by an independent agency.
John, when you look at that, and so that's why you referred it to the state AG, what would there have been that kind of conflict if it was in the grand jury? I mean, if you kept it here in Northampton County, do you think there would have been that conflict?
Well, one of the purposes of a grand jury is to do the investigation. The grand jury is an investigative tool, and it's often used when traditional investigation methods are inadequate. So we bring people in to compel testimony and things of that nature. So I thought about that, but the fact in this case is that the investigation is complete, and there was no witnesses that I'm aware of that were unwilling to talk, et cetera, that we would need a grand jury necessarily to just present all the information to the grand jury. In addition, I also noted that, in the grand jury we have county citizens from all over, including people who live in Easton, the city of Easton, and in Palmer Township. And although they do hear cases involving stuff that goes on with them, this is a little different because it involves a police officer in their community too. So looking at that picture, I decided that it really wasn't necessary to send this case to the grand jury, at least from what I know, to enhance the investigation. I believe that the facts now are already present in the reports, the witnesses. We have a video of everything that happened from the minute they engaged this individual. Police cars following it on a 20-some minute chase through the community, leading up to the crash on video and the shooting itself. So this is not going to be a situation where we have discrepancies necessarily of, oh, I saw X, Y, and Z. We see everything of what happened here. It's on the video, and all the witnesses are pretty much consistent because they're mostly police officers that are around what's going on at this situation. So it's a little bit different, for example, than in the Ferguson situation where you had conflicting testimony, fact determinations that had to be made, and the grand jury might have been useful to help compel testimony to flush some of that stuff out. But I didn't see that in this case, so I opted for the Attorney General's office.
We have a grand jury, or we have an Attorney General right now who is under intense public scrutiny. Her competency has been called into question not only by just about every major news outlet in Pennsylvania, but also by the Philadelphia District Attorney, Seth Williams, who essentially has called her a liar. And she is under investigation right now by an investigating grand jury. Doesn't exactly give, it's still a lot of confidence in the Attorney General to make any kind of decision. And I'm wondering whether or not, I realize that the statute providing for a independent prosecutor is not valid, but is there a basis under which a sitting district attorney could seek the appointment by the court of an independent prosecutor to make this analysis?
Yeah, I don't think we have that authority, Bernie. Years ago, there was cases that came down where DAs tried to do that in cases, and I believe that it was struck down because we have what's called the Commonwealth Attorneys Act,
right,
which is the act that basically says when a conflict of interest or perceived or actual conflict of interest occurs, the district attorney is to refer the case to the Office of Attorney General, and that's the procedure that we have formalized. Now, as far as your concerns about Attorney General Kane, I'm aware of all that, but I will say that the people in the criminal law division, like Mr. Churba, who I've dealt with in the past, he's a former assistant DA in Bucks County, someone that we know. He's running things pretty much in the criminal end of that, and probably will be supervising this personally. I don't know if this will ever get to AG Kane herself. But despite the problems that the Attorney General's office has had and the criticisms leveled at it, their business is going on as usual. I mean, there's drug raids going on. The work of the office is still going on regardless of her personal issues. And at this point, we prosecutors in Pennsylvania have an elected Attorney General. Until she's, if she gets voted out of office or she resigns or something happens down the road. But as of now, it's still what it is. It's criticism and matter of opinion. I'm well aware of it. It's obviously something that I am concerned about just across the board, and DAs have been discussing the issue generally among ourselves about the situation in the AG's office. But I'm pretty confident that there's a whole layer there in the criminal division of people who are former district attorneys, some experienced people like Mr. Beamer and others who are the first deputy, that are going to take a look at this case, and I have confidence that it still will be decided. Again, this investigation was done by PSP. This is a situation where someone has to look at it without bias and make a decision, a charging decision as to whether or not deadly force was or not used. So, wherever you turn here, there's criticisms. If we keep the case, there will be people who will say it should go to the AG's office. There'll be others who say, oh, Morganelli should have kept the case because, some of the concerns you've raised. But ultimately, I feel more comfortable with the idea that someone who doesn't know the officer personally, as I do, someone who's not connected with the police department as intense as we are, we deal with the Easton Police here every single day in our office, and the fact that, I do have some acquaintances now that I know are related to the victim's family. These are reasons why we have that Commonwealth Attorneys Act to get the case into the hands of the AG. And I think the most compelling reason is that my history here of these kinds of cases speaks for itself, that in the last 3 major cases that we've had involving police shootings resulting in death, we have been consistent in sending these up to the AG's office with varied results. As I indicated, one case, the police officer was charged, one case not charged, one case ruled accidental. So I don't know what the outcome of this will be, but I think that it will be based solely on the facts and not be influenced by any personal relationships.
So, John, in this case, how many, will there be more witnesses called, or are they just going to look at the reports and the findings that you already have?
Well, I believe that'll be up to the Office of Attorney General. I believe what will happen first is we have been delivered to me as 2 big notebooks about that thick, filled with all the actual statements of the police officers, all the witnesses they interviewed. The video itself is included in that. I believe the first thing will be a review and probably a meeting with whoever's assigned to this case by the OAG with the investigating trooper, and we've given that information to Mr. Churba. And then beyond that, it's their call. I mean, if they feel that there's needs to be more, they could ask the police to do more. I don't expect that, because I think the PSP, from what I've seen, has done a thorough job, and there's certainly enough information in there to make a decision. It's going to be a matter of reviewing the law and making a judgment about the use of force. But that will be up to the AG. They could put this before a statewide grand jury if they so choose, but that'll be their decision. As I said, in 2 of the cases, they did not. They just, based on the investigation of the police. In one case, which was the Solomon case, I believe they actually did utilize the grand jury in part.
John, did did Josh Carrolley provide any new information, or was there anything that he contributed that
I've contacted Josh at least 3 times and left messages for him. He did call me. We never really hooked up, and so we had not met. But he had a baby like 2 weeks ago, and he's in and out of the office quite a bit. So I have not met with him. I'm still open to the invitation for him to provide any information more that's not in these reports. But if he does, then I'll just forward that off to the Attorney General's office as well.
This decision suggests that it's not a clear-cut determination, correct?
Well, I wouldn't necessarily read that into it, because all 3 cases I set up, I had my own opinions about all of them just based on the information I have. So it's hard not to draw your own conclusions, and I never communicated that to the Office of Attorney General in any of the previous cases. So I think that all these are difficult. In fact, as I recall, when General Fisher, in one of those cases, he was actually quoted by saying what a difficult decision it was. You're dealing with split seconds of time and reactions, and so I wouldn't think that this case is any different than the 3 that I sent up. There are always difficult cases when you're evaluating people's responses. But I don't think you should read into the fact that somehow I looked at this and automatically concluded that the officer did something improper, and therefore I don't want to make the decision. In all the 3 cases I sent up, as you saw 3 results, and they were all based upon the findings of the investigators at the AG's office.
You are dealing with one Easton police officer, though, correct?
Yeah, I'm dealing with one police officer in the city of Easton. I don't know if this information has been out there or not, but I think it's fair to say. On December 8th, when I met with the investigators, what I learned in that case was the Palmer police officer that fired his gun did not fire at the victim. That was fired at a tire of one of the vehicle to attempt to help to disable the vehicle. So there was no use of deadly force on the person. It was a purported intentional shot at one of the tires of the vehicle of the truck.
Okay.
So right after that meeting, I did contact Chief Palmer of the Township Police Department, right? And I informed him, that. I mean, I think he already knew that. But that officer was on some kind of limited duty, as I recall, and I indicated that based on what I saw, that was pretty clear. So, those matters are clear. It wasn't use of deadly force. His bullet was into a tire or something. And so what we're dealing with is one officer here in the city of Easton.
Does that mean he shot the guy twice?
Yes, that's what it means, yes. Any other questions at all? All right. Well, thank you for coming out on this late notice. And,